For you folks out there that love the Constitution and the rights that it gives we citizens and the protections that it gives us, wow, I have a monumental court decision to share with you today. This is a big one, okay? Here's what happened. Now, let's just start from the basics, right? We have this piece of paper, and it's like a contract between us and the government, and it has protections, and it says, look, government, you can't do certain things to your citizens. And there's a Fourth Amendment to this document that says, we citizens shall never have an unreasonable search or seizure from the government. Now, these things do happen all the time, unfortunately, but this Baxter decision now says that 80%, 90% of the searches out there need to be thrown out in the future and cannot happen anymore. This is monumental. So the first page of the Baxter decision is, and it's a whole bunch of judges, what we call en banc. And their first line is, we have been presented with an issue of exceptional importance. Yes, this is huge, exceptional importance. All right, let me get to the meat and potatoes of this. Little history, folks. I've been doing this for 31 years. And for 31 years, the government gets to search your car and gets to search everyone in your car. If I'm in my car with my wife, they're going to call a female cop. Everybody's going to glove up and they're going to search everything if they smell weed. And this is a super huge inconvenience. And it's super difficult from a criminal defense perspective to challenge an officer that says, well, I smelt weed, and therefore I get to search everyone and everything. And they don't even find weed half the time. They might find guns, they might find cocaine, they might find other things. But you would be amazed how many times they supposedly smell weed and yet don't even find it. But that's a story for another day. And the Baxter case is going to eliminate this. This is monumental because here's what happened. Baxter was parked in a CVS parking lot and he was approached by a cop. You may say, who cares? Why? Why does this matter? Well, the CVS was closed. And ladies and gentlemen, anytime you park your car and decide to hang out, don't park your car and hang out late at night in the parking lot of a closed business. You are going to attract officers, and that is what Baxter did. He's parked in a closed CVS parking lot, and the cops come up and they want to ask him why he's there. But what ends up happening is the cop smells weed. And now all bets are off. Now that the cop smells weed, he searches Baxter's puts him in cuffs, searches the entire car, searches Baxter, and of course, he actually finds weed, which does happen on occasion. And Baxter gets charged and convicted of this, but he appeals it and he says, look, we have some changes in the law that make it so that this cop shouldn't have been allowed to search me in my car based on the odor of cannabis, because federal law now has legalized hemp. Florida law has legalized hemp. Florida law has legalized cannabis. The stuff that is illegal is now legal if you got it from a pharmacy, right? All these changes, Baxter's attorneys are saying, and we defense attorneys have been saying for years, no longer permit the government to start a search based on the odor alone. Now you may say, John, what do you mean? What's going on here? Well, look, back in the day, if a cop smelled weed, this is evidence of a crime, right? They know that either a crime was committed or is about to be committed. And when you are in a car and when a cop thinks that a crime has been committed or will be committed, it is considered reasonable for the government to search you and put on the gloves and do all the things that they do. This has been going on for decades. And now, is it true that the smell of weed will still instantaneously give a cop proof or evidence that there is a crime afoot? No, those days are over. This could be hemp. This could be medical marijuana. Those days are over. And that's what the Baxter case is about. So what I'm really talking about is the plain smell doctrine. The plain smell doctrine is just a fancy legal term for if an officer can sense that an illegal substance is being burnt. That could be crack too. That could be crack cocaine. But if it's crack or if it's weed, whatever it is, bam, everything shuts down. They call for backup, and they're going to search everyone. They're going to search everything in the car. Baxter is rejecting that. The 5th District Court of Appeal has said, you know what? This is no longer evidence of a crime. You know what? This could be evidence of hemp. You know what? This could be evidence of somebody having a medical card. We have to stop letting our citizens be searched just because a cop smells cannabis. We have to stop that. Now, the case goes into a lot more detail, like 19 pages of detail about the hemp laws. You know, hemp was legalized in 2019. The federal government legalized it. The state of Florida legalized it. It is the same exact plant as illegal marijuana. It is just different because the Delta 9 THC in a hemp plant is 0.3 or lower, and that is perfectly legal. You can have THC, you can burn it, you can do what you want with it. It's called hemp, and it has to have 0.3 Delta 9 THC in it. However, if you exceed that amount, that used to be illegal marijuana. It is not illegal anymore in the sense that if you got it from a pharmacy, it would be perfectly legal. If you got it from your buddy that you've been getting weed from for the last 10 years, then it is illegal. Same exact substance, but if it comes from a pharmacy, it's legal. If it comes from your buddy, it's illegal. But basically, the Baxter case stands for the proposition of this. The incremental legalization of certain types of cannabis at both the federal and state level have reached the point that its plain smell does not immediately indicate the presence of an illegal substance. As a result, the smell of cannabis cannot on its own support a detention, support probable cause, support a search. Ladies and gentlemen, this is huge. I don't know how far the other courts are going to side with the 5th District Court of Appeal because we have 6 district courts of appeal in Florida, and we have a disagreement right now. The 5th DCA says you can't, from here on out in the 5th District, you cannot search that car based on the odor of cannabis alone. Can't do it. Other districts have found differently. Other districts have said you can still do it. This is going to go up to the Florida Supreme Court. I hope that the Florida Supreme Court makes the right decision. Ladies and gentlemen, if this decision gets adopted by the Florida Supreme Court, we are going to see changes in law enforcement's approach to citizens and yanking them out of the car and doing all the things that they do. It's going to be amazing. It's going to be a different world here in Florida. So I'll keep you posted.